Good morning. Captain Matt Edwards retired here with another one of my Facebook Live broadcasts. I'm going to try to keep this one as short as I can. I'm going to be talking about what I call Veterans Affairs Canada's infernal review process this morning. So basically, under the old system, you had a Pension Act that if you weren't satisfied with the Veterans Affairs decision, you could appeal to an allegedly outside agency called the Veterans Review and Appeal Board. Now, the Veterans Review and Appeal Board, or VRAB, I guess, they basically, in 1995, became part of Veterans Affairs. Prior to that, they were the Canada Pension Commission. I have a firm belief that this should go back to the way it was, and you should have a commission, and you should remove the Bureau of Pension Advocates as well from Veterans Affairs to remove any hint of bias, because bias is what I'm going to be talking about today. Bias in Veterans Affairs not wanting to review its own decisions and change its mind. So anyway, they brought in a suite of benefits according to the Canada Gazette in 2006 to change the Pension Act from what they said was a one kind of payment, and they wanted to change the way they compensated veterans. Now, it is my submission that if you change a system and you want to change it into a split off variety of payments, instead of having one single payment. Now, the one single payment had an appeal right to the VRAB. So then all of the alleged benefits ought to be able to get appealed to the VRAB. All of them. There shouldn't be any what I call infernal review. You shouldn't have anybody. Okay, the Baker Supreme Court of Canada in 1999 said that no one should have their rights and entitlements decided by an unjust process. No one should have a right to a remedy without some way to get it. You can't have a right without a remedy, okay? So, I was reading that in the 2006 Canada Gazette, I was reading so much shit that I couldn't believe it, right? They were saying that, oh, we don't expect there's going to be very many conflicts because, this is a informal process where, case management and rehabilitation and job placement and all that. Oh, we're working with the veterans. There won't be any disagreements. What were they smoking? People always have disagreements. Now, I have my notes made up, but I'm kind of winging it here, so I'm just going to wing it until I stop winging it, okay? People will always have disputes. You're the only person in a location. You shouldn't dispute with yourself. But anytime you have two people and then their rights and interests start intertwining, then you're going to have disputes. So you had to have some form of dispute process. When I was a Canada Revenue Agency worker, we had a grievance process. It had 4 levels of internal review where you went to the manager first, then you went to the manager's manager, then you went to the regional director, and then you went to the national director. Now, if you exhausted all the 4 levels of the internal processes, it would then go to the Public Service Labor Relations Board for an external review. Now, the thing about the process there is that it was a union-driven process and that they could say, because it's their contract, that we don't want to support your grievance. They could throw you under the bus because they could look at your grievance, see that it might adversely impact more unionized members than you, and they might say, Matt, you're entirely right, but you know what? We don't support your grievance, and because it's our contract, you have no right to go try to get it. Because you are bound by a contract, and in that contract is the agreed upon redress process. Now, Veterans Affairs, in its 2009 internal audit on the infernal review process, of course they called it the internal review process, they claimed that it was based on the healthcare regulations. Now, that's one of the times that I might have to admit a mistake, because I always either assumed or I read somewhere else, or I thought it was, that SISIP, because the earnings loss benefit is based on SISIP, then I assumed, or whatever, that SISIP had a same internal review process. Now, the Sun Life policy, which I have as well from being disabled from CRA, that has 2 levels of internal review. So I think I can be excused for thinking that it was a copy of SISIP. Now, there's nothing in the SISIP policy, so I think that they follow the same thing that Treasury Board does for the SISIP policy. There's 2 levels of internal review followed by a review at the National Joint Council, it's called, where there's a board of management with 4 union appointed people and 4 management appointed people and a chairperson. Now, that brings me to a point that's very universal generally. When you have something like a labor dispute, usually you have a say in who can be the adjudicator of a dispute, sort of like a veto. Like Veterans Affairs is trying to tell us, and I meant to, and I will post it to my Facebook group later. I will post a letter I got from former Minister of Veterans Affairs, Kent Hare, in which, in 2016, he tried to tell me why this was fair. And he tried to point out that even though it goes to another Veterans Affairs, so I pointed out that if I get a negative decision from Veterans Affairs, and then I put in for an internal review, and the first level of internal review, they review their own decision. So why should I expect them to not back up their friends and their policies and how they interpret it? Now, if that person then tells me, no, I have another internal review, and then I can ask that it get reviewed again. Now, Minister Hare said that it will be sent to a more senior person, and I should be assured that that would take care of things. But everybody ought to know that if you go to the same people who told you no, and then you expect to get them to change their mind, I mean, you're pissing in the wind. You're whistling Dixie. Look, why would they? Why would they expect someone within the same organization to disagree with the previous person? It goes against all common sense that any person should have. Now, I was talking to a member, a head of a fairly large veterans organization on Facebook yesterday, and I was telling him a lot of things are common sense. He said, well, what exactly is common sense? Now, I tried to explain to him that it was what are reasonable, things that are reasonable, but after I hung up, I was talking to him for 2 hours and 20 minutes, I thought of another point. It was in the Great Western, Bradburn versus Great Western Railway case in 1875, and it talked about the ordinary man's sense of justice, okay? To me, that's kind of common sense, okay? If you have enough sense to look at your version of the situation and you say, well, if I go to Veterans Affairs and I ask them to review a decision they made, well, my sense is that they won't give me a fair shake. They won't give me a fair shake. They won't treat me fairly. They'll just try to save money by backing up their buddies. Now, unless somebody can point out that the, I'm trying to recall the natural justice phrase, it's called nemo judex something something. Okay, I don't have any Latin training, but it means that no man may judge his own cause. So, of course you're going to back up what you did, right? Why would you say we made a mistake? Now, in preparation for this, and I'm speaking a bit faster because I want to be finished quicker. I don't like to talk. That fellow I was talking to yesterday for 2 hours and 20 minutes, he probably thinks that I like to talk, but I don't. Okay, I'd have no need to talk at all if they did it right. If they had an independent board, how could you complain? If you went to a board and they were independent from back, truly independent, and they said you were no, you would have a lot less to have a grievance for, because then you would have to go to the outside courts and you'd have to find a cause for appeal. But right now they have a system where if you're not satisfied with the decision, you got to ask the same people to change their mind. Now, I don't see how anybody, I think I would, I think I've had situations like that because I have obsessive compulsive personality disorder. I cannot tell a lie. It sounds stupid, but it can, right? I can't. I just get sick physically. But the thing is, most people aren't like that. Most people have a sense that if they get what they want, they're happy. Now, when I'm looking at the infernal review, and then I'm trying to say, well, you know, this is crazy. Why are they doing it? Well, they're doing it to save money. Okay? If they have a process where they strip you of your right to be heard, then they save money because they don't have to pay. Now, how many veterans, how many soldiers know their rights? Okay? Most soldiers look down on civilian workers, and I'm probably, anybody who's watching as a civilian might not like to hear that, but they think that, you know, we're tough enough to take the rule, you know, go to war and get trained and do all this stuff, but them civvies are too soft. So the thing is, nobody should have their rights interfered with like this. I've seen, and I believe, that the country and the rest of the world has had a huge reversal of all the rights that were fought for over the years, all the rights that unions went on strike for, and people got hurt and people died fighting with their employer, trying to get fair treatment in the workforce. Well, soldiers don't have a union, and the government just put the boots to them, okay? For example, in the Service Income Support Insurance Plan, there's a 2% cap on the cost of living. So if you were medically released, say in 1976, and you were on that program all those years, back in the 80s we had a high rate of inflation. Now there was a cap of 2% on those people, and they went into poverty because their insurance did not keep up with the rate of inflation. Now that is unjust. I don't care if they could say it's legal, it's in the contract, it's unjust. So the thing is, the Veterans Affairs, when they copied the earnings loss benefit in 2006, put the same cap into place. But in 2016, only 10 years later, they came to their senses and removed it. Now, if this goes to court later and we decide to challenge that and say, listen, the Service Income Support Insurance Plan has to follow the same rules as the rest of the government, we point out that Veterans Affairs already did it, so that proves our case. Okay, there's no big elaborate case that's required. All we need to go do is say this is what the government policy is. Injured veterans get more than 2% if inflation is more than 2%. Now, going back to the subject of the day, I mean, I don't know what's going to come out of my mouth when I start these things. Maybe that'll increase the viewers. But the thing is, okay, I was looking at something the other day on the internal review reports that audits that Veterans Affairs had. And they said, you can look it up. I posted the link to my group. And I can go get the figures later. But they said, I think 1 out of 16 cases, which is very small, 6%, was approved on one level, and 0 out of 9 on another level. Now, I don't know if it was the first or second or whatever. It seems to make sense to be 16 on the first review. 9 people decided to take the second review, but that is a shockingly low figure. Okay, so to compare that, I looked at a 2012 Office of the Veterans Ombudsman report, and they studied the Veterans Review and Appeal Board's review decisions from the I don't know what period, but they said there was a 50% overturning of Veterans Affairs decisions on VRAB. Now, you compare a 6% to a 50%, and that's a huge difference. So I believe that they cannot justify this crap. They cannot justify a breach of what you call natural justice. Nobody is supposed to have a biased person hear their case. Now, how can you have a good case if the person who did the case is rendering their own decision, reviewing their own decision? Now, there is a reconsideration process called the Minister's Own Motion in the Act. So in the Act, they do say that, you know, if the minister notices that there's an error of fact or law in a decision, then we can overturn it. Now, they're talking about not the real minister, but the delegated power that's put down to the Veterans Affairs employees. Now, as someone who's not a lawyer but has studied a lot of law during my research for my book and all these live broadcasts and whatever, how would a Veterans Affairs employee, who I presume does not have any legal training, would they know an error of fact of law if it came out and bit them on the nose? Would it? Would they realize that if someone complained, for example, that, you know, the earnings loss benefit clause back the value of the Canadian Forces Superannuation Act pension, but, you know, the Clark versus Clark case in 1990 said that the pension was property and not income. So the whole premise behind a clawback is to reduce one form of income for another form of income so you won't have too much money. But the pension is income, not income, it's property. So if the pension is not income and it's property, they're proceeding on the wrong premise, okay? So the person at Veterans Affairs wouldn't know how to deal with that. They would be just towing the party line, and a lot of people believe that they hire sheep, people who are willing to do what they're told. Well, soldiers are mostly willing to do what they're told, but we are allowed to refuse an unlawful order. Now, the other point I would make is that they said an error of law or fact. So they might have some facts wrong, right? They might presume that the Service Income Support Insurance Plan is compensation for injury. But the Service Income Support Insurance Plan, and I know this because of the SOLTS, Sierra Uniform Lima Zulu, British Columbia Court of Appeal, in the year 2006. And a year prior to the Dennis Mnuchin class action, they said that the Great West Life Plan for the RCMP was a non-indemnity and contributory insurance that you get in addition to your damages. So she got her $950,000 damages. She got her Canada Pension Plan Disability because that was non-indemnity. She got her Great West Life because that was non-indemnity. And she got her Canadian RCMP pension because that was non-indemnity. The only thing they clawed back was the Pension Act pension. So the province of British Columbia reduced their damages to that lady because she received a Pension Act pension. Now that goes directly in the face of the Dennis Mnuchin case. And people might not like that, but you know, the judge in the court over there was kind of right, because the Pension Act is an indemnity for loss, and I covered that previously. Go back and have a look at the copy on Facebook. But my point is that if you get an indemnity, you're entitled to your non-indemnity contractual insurance. So if you get an indemnity, and it might be the ELB, it might be the pension, but you are entitled to your insurance. So you're entitled to get your CISIP plus whatever else you get. Okay, you're entitled to get your Canadian Forces pension plus whatever else you get. You're entitled to get your Canada Pension Plan plus whatever else you get. That's the law. Now, if you put in an internal review on that to Veterans Affairs, they'd say, well, we have to obey the law. The Veterans Wellbeing Act regulation tells us we have to take it into account. But the thing is, going back to the Baker case in 1999, it talked about discretion. Okay? So, if a Veterans Affairs employee, a case manager, is looking at your file and they're saying that you got the Canadian Forces pension or the Canada Pension Plan, then they ought to have the discretion not to take it into account. And I'll give you a concrete example, because the reason I talked to that veteran that, yesterday for 2 hours and 20 minutes was I wanted to find out if he was a victim of the double dip clawback. And the double dip clawback is my flagship product, I guess, the one that I want people to start noticing, because I think it'll start sinking their boat. Okay, we have the Department of National Defense CISIP program that is supposed to be the first payer on medical release. So then in October 2016, we had the Veterans Affairs Department said that we're going to pay 90%. CISIP didn't increase their payment, so VAC topped up the other payment. Now, instead of simply saying to the veteran, listen, you getting CISIP? Yep, okay, well how much? Then they could work from there. Instead of doing that, what they did was they decided to ask all the same questions. And do you get the Canada Pension Plan? And then they reduced their ELB. Do you get the Canadian Forces Pension? And then they reduced their ELB. But the Department of National Defense had already used up that clawback. You can't claw something back twice. That's insane. Okay? The Canadian life and health insurance industry has a policy. The policy is that when two insurers are in a dispute about who gets to claim the Canada Pension Plan, as an example, then they share it 50-50. Now, instead of sharing it 50-50, which might have kept this from getting exposed a bit longer, the government's blindly following the rules, because I've read Supreme Court of Canada cases about you can't just blindly obey the law. If something led to an absurd result by blindly following the law, it shows that you did the wrong thing, because you're not supposed to just say, I did it because the law said so. My commanding officer in the unit, he was a very hard liner. He said, for example, people who were driving the trains to the Holocaust, putting the Jews into concentration camps, they should be charged and put up against the wall and shot. But there's a thing called the Nuremberg defense that says the lower you are in the food chain, in the chain of command, then the less you're expected to question orders. So if you're a private in the German army and you blindly followed orders, you wouldn't get as big a punishment. Sure, you should have known it was wrong, but you still had to worry about them putting you up against the wall if you didn't do it. So the thing is the commanding officer I got, he was kind of wrong, because you got to take into effect the context. So in the case of the CISIP clawback and then the Veterans Affairs clawback, well, you have two different departments saving money at disabled soldiers' expense. Now that's the bottom line. You have the Department of National Defense that takes into account the Canadian Forces Superannuation Act. Well, what's its justification? It's in the policy. Well, did you get a chance to write that policy? Did you negotiate that policy? How did it come to be in that policy? Okay? So we had the Pension Act, which was in the policy, but then all of a sudden, after 36 years, from 1976 to 2012, well, it was being done, but then it got challenged in court, and then it got struck down. Now, so all the people that thought it was okay for 36 years, they found out it wasn't okay. and it went to the federal court, and then it ruled in their favor. Now, the government pulled a fast one, and I'll mention it, the Toth class action. They said that the people on the earnings loss benefit who were having a clawback as well, they only went back 4 months, versus the SISIP case went back 36 years. So I wasn't part of either suit, but it offends my sense of justice, my ordinary man's sense of justice, for the government to do that. So I set out to try to fix that, and I tried to point out that this was bullshit, okay, because SISIP was copied by the earnings loss benefit by Veterans Affairs, and if the case was about the Service Income Support Insurance Plan, which was copied by the earnings loss benefit, then you had to follow the same rules. And at the time, if I had known about it, because I came across it later, there's a thing called a program arrangement. The program arrangement was signed by the Department of National Defense and Veterans Affairs in 2006. It alleges that it can take the Service Income Support Insurance Plan and make it the first payer on a medical release. I say they're full of shit. Why I say they're full of shit? Well, from 1976 to 2012, the Pension Act was the first payer, and the Service Income Support Insurance Plan took it into account. How did you get to be a complete reversal in the program arrangement, and all of a sudden they said that the Service Income Support Insurance Plan was the first payer? Answer me that. They can't. Okay? It can't be the first payer because it's a non-indemnity and contributory insurance payable in respect to the risk that you paid a premium for. And if the risk happens, you're supposed to get the insurance. So what they're doing is they're trying to get your premiums without having to pay the insurance. Now, I think they have internal review. Getting back to my topic. Okay, so internal review is very flawed. Now, in 2016, see, here's my case. What I told I got a contact in the OVO, and I got a contact at deputy minister level, and I'm trying to get my own situation fixed too, but I think I'm persona non grata. I'm blackballed. I'm blacklisted, I believe. Now, some people think that that might not be true, but I can assure you that it happens. The thing is that I'm too outspoken, okay? But I want them to follow the rules, because the government is supposed to put its personal interests aside, and the government is supposed to act in the public interest. So they might not like Matt Edwards because I'm criticizing them, but they are not supposed to treat me any worse, because A, I was a reservist, B, I became disabled in service, and C, I speak up against them. I have freedom of expression. We don't have freedom of speech in Canada. I can speak up, and I can speak out against unjust processes. If I was still employed with the government, I couldn't say all these things because there's a duty of loyalty. But I still kind of follow the duty of loyalty's premise that you have to try to exhaust all internal means first. So I have been, over the years, passing information on, say, to Canada Revenue Agency about how they're not supposed to do this and that. I've been passing the information on to the Internal Disclosure Office of the Canadian Forces. I asked them to investigate the fact that the government does not take the Canada Pension Plan and the employment insurance off of the earnings loss benefit and the SISIP program, even though it does it for all the different private insurances across the country. So Canada Revenue Agency has taken employers to task in the past, like the Université de Laval Federal Court of Appeal 2002 case, and the National Bank of Canada Federal Court of Appeal 2003 case, and the Toronto Transit Commission Federal Court of Appeal 2010 case. So they have been taking private insurers, private employers who are insuring their own employees to task because they only took tax off and they didn't take out EI, or they didn't take out EI and CPP. And you see, that's not right. If something is income and not insurance, you're supposed to take all of it out, okay? If it's income, if you go to work for an employer, then they have to take all the statutory deductions out because the government passed laws and the laws have to be obeyed. You are bound by the law to obey that. Now, employers didn't take out EI, so CRA took them to court and won. I don't think they should have won. I can do a whole broadcast on it later, but basically insurance is not income. You're not getting money in relation to your service, you're getting money in relation to the premium you paid. So you paid a premium, you become disabled, and then the risk that happens, you get the insurance. That's it, right? So you shouldn't be taking out tax, you shouldn't be taking out EI, and you shouldn't be taking out CPP, but the government wants more revenue. The government wants revenue for all these programs. The taxes go to general revenue, the employment insurance premiums go to the EI program, and the CPP goes into the plan to support it. Now, why aren't SISIP and them doing that? Why isn't the earnings loss benefit doing it? It has been reported. I'm getting kind of off track, but hey, bear with me. The Veterans Ombudsman and other people have said, people that are getting out and then they haven't contributed enough money to their Canada pension plan at the end of when they hit 65 and they go to get the Canada pension plan, they're not going to have any money to get because they haven't had money taken off of their check. Well, they're kind of right. They're kind of right, except for the fact that it shouldn't be taken off. But they have a point about they're going to be penalized, is what I'm saying. So if you're serving in the military, you get disabled at, say, 5 years. So that meant because you had to serve 48 years in a position to get a maximum, 47 years to get a maximum Canada pension plan. That means you lost out on 42 years worth of Canada pension plan, and you're going to get a piss poor Canada pension plan at age 65. So they are right, okay? But the problem is they bring in all of these stuff, and basically, yeah, thanks, Michael. I appreciate you watching, buddy. So what they're doing is they're trying to look at this as a broad picture, the whole of government, okay? So they're trying to look at this, and they falsely believe that the Canada pension plan is paid by the government. It's paid by the government administers it, but the Canada pension plan is a self-insured policy of insurance, okay? The Canada pension plan was brought in 1966, as we all know from the bridging thing, which is going to be an episode in the future. And the thing is the Canada pension plan has no government support, no government anyway, they're not subsidizing it. They're not putting money into it. They're not giving you money that you didn't put into yourself. So what happens is, and here's how the Canada pension plan works, I've talked about it in the past, the government wrote a law, the Canada Pension Plan Act, that requires employers to deduct money from your check, and then they require them to match it 100%. So the employer puts 2 payments in the mail. One is from your check that they deduct from you, and one is made on your behalf. Now both of them are yours. They falsely think that they paid it. But there's no requirement under the Canada Pension Plan Act for them to make a payment. They don't get any benefit out of the Canada Pension Plan. That's one of my problems I got with self-employed people. I was never self-employed. But if you're a self-employed person and you want to get a Canada Pension Plan pension, you had to pay both halves. But you don't get double the money. You don't get double the money, and that proves my point. The money from the CPP that I used to collect as a CRA tax collector would get sent to the government, and then it would get matched up with the part, from the employer. The money from you and the money from the employer get matched up, and then CRA sends it to the Service Canada people. That's how it works. It doesn't stay in CRA's revenues. But the thing is that was paid entirely by us. And you want legal proof? Because I always quote off cases. Gronowski, Supreme Court of Canada, year 2000. Okay, they said it's entirely paid by us. Now, that also applies to the Canadian Forces pension. That also applies to any federal government pension. You get the RCMP pension, the Public Service pension, or the Canadian Forces pension, you're not getting any generous pension. You're getting your own money back, okay? You could have put that money in a bank account, an RSP, you could have pissed it away, you could have done whatever you want. However, the government passed a law to force you to save for the future. They put an obligation on you to make your own savings. That's what it is. Roy, Federal Court of Appeal, 2003 is my source. I didn't need to read that in that case. I knew it anyway, right? Schmidt versus Air Products, Canadian Air Products, Supreme Court of Canada, 1995. A pension is for the sole benefit of the pensioner, not anybody else. So the fact that the bridging, and I'm getting off topic a bit, is not about internal review, the fact that they reduced the Canadian Forces pension, RCMP pension, and the Public Service pension on account of the Canada Pension Plan is a violation of pension law. It is not to anybody's benefit to have their pension reduced. Now, that has been addressed in the past, and people are trying to fight it, but it's hard to fight City Hall, as they say, right? Everybody has these notions that, getting back to the topic at hand, the Infernal Review, in that report in 2009, I read that they said that they copied the health care regulations appeal period. So I went and looked that up this morning, and yeah, they're pretty similar. But then it occurred to me that I think everybody across Canada, all the different organizations, all the different governments, all the different insurances, all the different workers' compensation, they do the same thing. So they think that popularity equals legality. But they ought to know, they either know or ought to know, which is a term in law, they either knew or ought to know that the Baker Supreme Court of Canada said that the government has a duty to act fairly. The government can't just say, well, we said it, so that's it. End of story. There is a legal duty on the government to act fairly. Now, maybe I could go back and review it and see that it's about treating people fair, which is natural justice. But basically, everybody ought to know that the government is us. Okay, so we vote for the elected member of parliament. We might not vote for the winner, but we had a choice. We had a chance to participate. When they get in power, they have to act in our best interest. They have to act reasonably. They can't just get in because they got elected and do whatever they want. Kind of like Donald Trump, one of the fellows that I hate because he seems to be a wannabe dictator. People, unfortunately, a lot of veterans seem to like this asshole. But you know, he's trying to destroy democracy. I view democracy as my religion almost. Okay, I was watching a show, a documentary one time, and I was talking about people being swayed by things. And they said, "What's your favorite color?" And buddy said, "Red." No, buddy said. Then the interviewer, the documentary said, "We'll give you $50 to say it's blue now." People would normally switch just to get the money. But when they got to things like religion, people wouldn't change their view no matter if you offered them $1 million. I view democracy as my religion, and the government is trying to undermine our democracy by not letting us have a fair shake in, say, the internal review process, in the clawbacks, in all these things that they're doing to try to save money and try to justify things. For example, in the Canada Gazette, they said they had a prudent safety margin because of all the different clawbacks. When they set up the earnings loss benefit, they said they had lots of wiggle room. They had lots of profitability because, well, they had all these things they could take into account. Now, I was talking to that veteran up in Ontario yesterday for that 2 hours and 20 minutes, and I said to him, "Listen, you were getting the Pension Act used to justify the reduction of the Service Income Support Insurance Plan. Do you get the Canada Pension Plan? Yes. Do you get the Canadian Forces? Yes." I said, "Then I bet you after that case, they said, we can't send out the money yet. We have to see how the other offsets work." Now, I said to him, that's utter bullshit. If you stake your claim that you're going to use the pension as the primary vehicle to save money, after you get caught and are told by the courts not to do it, you can't change your mind then and say, well, we got a backup plan. We can use the Canadian Forces and the Canada Pension Plan to further reduce it. So, you know, a few years ago, I wrote a story about the double zero-sum veteran, and I said there probably are veterans who finished the Dennis Manouse class action lawsuit, and because they had too much Canadian Forces pension and they had too much Canada pension, despite the victory in court, they didn't get any money. Now, nobody's approached me to say that happened to me yet, but I bet you, based on the law of averages, the law of large numbers, that is true. Because I know they did it. But the thing is, can they do it? Now, they claim they can. And people, look, I mean, I keep telling you that I'm not a conspiracy nut or a paranoid. I don't trust the government because of reality, facts, okay? If for example, I applied to the Canada Pension Plan 4 times because I was forced to by Sun Life, the Treasury Board's administrator for my insurance. When I got approved, my children should have gotten a children's pension. Now, one of them got it, one of them didn't. So I called them up, naturally. You would think that they'd say, yes, we'll send the money out right away. Nope, that didn't happen. They said, you got to make a new application for that child. I said, now, riddle me this. You had to be in school, right, to get this Canada Pension Plan disability children's pension? Yep. Well, one of my sons is in university, and he is the one who got it. But the younger son, he didn't go to university, so he's no longer in school. I said, if I have to do up a new application for him, because he's disabled, if I have to do up a new application, are you going to go by the date that I just sent it in, or are you going to go by the date of my approved application? Oh, we're going to go by the date you just sent it in. Okay, well, getting back to that topic, I said, well, he's not in school anymore. You're telling me to fill out an application for nothing. You're telling me to send in an application so you can process it and then tell me, no, he's not in school, and therefore he don't qualify. Now, you can go straight to hell. I probably told them to go fuck themselves. But I told them to go to hell because that's a waste of time. That's a waste of resources. That is not just. What they should have said is, you know, we didn't send it out. Sorry. Here's his money. It's not my money. It's his money. But the thing is the government gets so caught up in trying to save money and bureaucracy and technicalities and the robotic and literal following the rules, even though it doesn't make any sense. Right? It's like when I did my CRA tax appeal. I called in, spoke to the appeals lady for 2 hours. I said, first of all, CISIP is not income, it's insurance. The purpose of the Income Tax Act is to tax income, not insurance. So therefore, you cannot tax SISIP because of the principle of the Insurance Act. Good point, she said. Secondly, I said, you can only tax a person when they didn't pay all the premium. So although the soldier didn't pay all the premium on paper, their service has value. Like in the Cunningham versus Wheeler Supreme Court of Canada case in 1994, Ms. Cooper paid 30% of the premium, but it wasn't allowed to be taken into account on damages. Now, it wasn't a case about damages. I was talking about taxes and not damages. But the legal principle is exactly the same. So the Supreme Court of Canada said they could have paid that money to her, and she earned it. That's why they didn't allow the insurance companies to take that long-term disability off of the tort damages, because that's what insurances do. The insurance wanted to save money on the car accident side by taking the long-term disability money into account. And they weren't allowed to because the Supreme Court of Canada said they couldn't. Because they went back to the Bradburn rule, which is what I keep talking about. The Bradburn rule said you can't do it. So don't do it. If you don't do it, you can't get caught for breaking the rules. But because they did it, and they are doing it, everybody across Canada is doing this. Earnings loss benefit takes into account SISIP, and that violates the Bradburn rule. Okay? SISIP takes into account the Canadian Forces pension, that violates the Bradburn rule. SISIP is a non-indemnity insurance. Now, a non-indemnity insurance has no right to claw back, and it cannot be clawed back. Now, that's a very important point about any non-indemnity payment. If you find out that a payment you're getting is a non-indemnity, which means not compensating, okay, they might try to tell us that we're getting compensated for our loss of income under the Service Income Support Insurance Plan. Bullshit. Because of its nature of being a non-indemnity, which is non-compensating, it's not compensating for anything, including income. Unless it was indemnity. If it was indemnity, it could compensate for loss of income. But because it's non-indemnity, it literally can't. Period. End of story. So, they just want to save money. And they try to justify the fact that, oh, we're looking at it for the taxpayer. Okay? Now, you're putting the taxpayer further at risk, because Dennis Mnuchin could have asked for punitive damages, because SISIP is a long-term disability insurance which is bought for peace of mind. The only benefit you get out of an insurance policy is peace of mind. So you're supposed to be able to rest, go to sleep at night, because you know you have insurance. And if the worst happens, you have something to fall back on. But they didn't pay the insurance because people got injured on duty. And because they got injured on duty and they got the Pension Act pension, then they reduced the pension, reduced the SISIP and didn't pay them. So they violated your peace of mind. So I said, Dennis, why didn't you do it? And he said, well, I didn't want the taxpayers to pay too much. Look, I'm trying to bite my tongue not to... He might not have won, okay? I'll sugarcoat it. He might have asked for punitive damages. He might not have got it. But if he had got punitive damages, which aren't related to your injury, they're a slap on the wrist, financial slap on the wrist to make sure it never happens again, then we might not have these problems now. We might not have the Canada Pension Plan being taken into account. We might not have the Canadian Forces being taken into account if they had got slapped on the wrist so hard that they would have questioned whether it's worth trying to save money. Right? That's my theory. Right? And I think my theory is true. Because they are running the litigation risk, you see. They're hoping to get away with it. But someone like me could look at my video. You guys, people watching this, could look at this and go out and get a lawyer and then sue the fuck out of the government. And you'd win. You'd win because they haven't got a legal leg to stand on. First of all, the Canadian Forces Superannuation Act, Section 83, says they can't do it. Why did the government pass that law? If it was then going to break that law with its Department of National Defense insurance policy. There's a legal principle called rule of law. So you can't make the law, make the rules, and then turn around and break them yourself. Right? You hear the Prime Minister. I'm biting my tongue here. I shouldn't talk about the Prime Minister too much. Every time I bring up something about Trump, veterans say, what about Trudeau? Well, I wasn't talking about Trudeau. If I'm criticizing Trump, stick to the topic. But Trudeau is always talking about the rule of law with that Hung whatever her name. Don't think I'm racist because I can't pronounce her name. I just don't have very good pronunciation. But there's a Chinese lady being held in custody in Canada, and I think we're being played by the Americans. She didn't do anything wrong in Canada. We were asked to help the U.S. by arresting her for extradition. And then China turned around and put all kinds of pressure on us by arresting people that did nothing wrong over in China. And you know what? Canada had no fight with China. We should have let her go as far as I'm concerned. But Trudeau keeps talking about the rule of law. But the rule of law in my mind is, what did she do wrong in Canada? If she didn't do anything wrong to Canadian while on Canadian soil, then we had no cause to arrest her. And if we had no cause to arrest her, why is she here? And why are we putting up with all this shit? So, I don't have all the facts, but on the surface of it, it seems to me that we're being played by the U.S. And it's having negative consequences to us. Now, getting back to the topic again about the internal review, Veterans Affairs is relying on our apathy and ignorance about all these programs. Okay, I'll give you an example. I called up the Veterans Affairs 1-800 line yesterday or the day before, or whenever last week, and I said, hey, I'm talking about this and I want you to make a note to my file. I don't think it's fair. They said, well, you had 60 days to appeal, as if it's my fault. Now, I reviewed the Act this morning, the regulations. It doesn't say 60 days. It has a caveat there. It has an exception to the rule. But you know something, Veterans Affairs doesn't say about that. They don't tell veterans about the exception to the rule, right? In the Federal Court Act, there was something like you have 90 days to appeal to the federal court for a remedy, or such time as the justice will permit. So the judge can look at your case, and if you tell them why, some kind of sob story about why you couldn't do it within the 90 days, they could still do it later. Veterans Affairs has the same thing under their law, but they don't tell us about it, right? Now, how can you know about the exception? If you called up and you told them that you were pissed off about a certain decision and you wanted to do the internal review process, they'd say, well, by 61 days, you're shit out of luck. Now, where's the justice in a strict application of the law there? So, I don't think that they give you the time of day if you did tell them you needed more time, but you know there is the exception there. They can't say it's not there. It's in the law. It's in black letter law. It's written right there that it's if the veteran couldn't respond, due to circumstances that was outside their control or something. Now, many veterans have a thing called, I bite my tongue because I always say white coat syndrome, but it's brown envelope syndrome. I had white coat syndrome. It almost caused me not to get in the military. I was in perfect shape. I could run miles and miles. I was in excellent shape. I went to go get my physical to join the military in 1999, and the petty officer didn't get things mixed up because my blood pressure was high, and he did the step test after he did the push-ups and sit-ups. So after I nailed the push-ups and sit-ups, I did the step test, and that's an indirect measure of your maximum ventilation of oxygen. Okay, getting to use some physical education degree. So instead of putting some stuff on you to see inside your blood how much your blood is using your oxygen, we develop tests that are less intrusive, such as a step test or a 20-minute Cooper run. Like you try to see how many laps you can do in 20 minutes, and then we do an indirect test to say this is how fit you are. Well, to be a soldier, you had to be really fit. And here it was on the first level, they said you fail. I scratched my head. I couldn't figure it out. I was walking downstairs with my paperwork, and then I realized that they did it backwards. Now, if you do a maximal exertion with push-ups and sit-ups in 1 minute, and you do as many as you can, that's called anaerobic exercise, and your heart will go through the roof. And then if you do an aerobic exercise, like the step test, well, you're going to screw it up. So I went up to the petty officer, and I explained to him my thing, and I'm a physical educator, said I never thought about it until I was walking down the stairs, but you did the test backwards. Now, I just thought of it that time. I was asking him to admit a mistake. He said there was nothing they could do about it. So I went over to Mon, and I went to the phys ed department, where School of Physical Education, where I did my degree, and then I asked them to do the test, because that's the fellow who does it for them, and he did it, and I aced it. You don't improve your maximum ventilation of oxygen in 1 week and fail the test week 1 and ace it the second week, okay? That's not the way it works. So you, at most, if you exercise more than 15 minutes for 3 times a week, you'll gain about 2% in maximal VO2, okay? Bringing in my knowledge of phys ed. Anyway, my point is people don't like to be told they're doing it wrong, right? And that's the internal review process. I think we need to go back to an independent commission. It was called the Canada Pension Commission. We need to have all of the benefits that are supposedly benefits paid by the government needs to be subject to the pension that they bring back. They need to have a Bureau of Pension Advocates that's independent again, and they need to cover all of the benefits and not just the disability award or the pain and suffering compensation as they now call it. I hate to say it, but you know, they have me so conditioned to not believe a word they say. I think the name is stupid, okay? Let me tell you what a name, the pain and suffering compensation, additional pain and suffering compensation, is dumb in my mind. They tell us all the time that they're really concerned about the veterans' welfare. Well, every time you get a payment every month, you shouldn't have a continual reminder of the pain and suffering that you're going through. They shouldn't name a benefit that's a direct reminder. They should find some stupid name that is so boring that it won't remind you of the pain and fucking suffering. Now, why am I having to say that, yelling at the screen, hoping someone's watching? Why can't they have a bit of fucking common sense when they're doing up these programs? Huh? Why? Why do all this stuff come out later? You know, back about when they brought in the VRAB in 1994, 1995, the opposition spoke up in the House of Commons and said, you know, this violates the principle of natural justice. Government did it anyway. I presume they had a majority because, you know, if they had a minority, the opposition would have been able to stop them. But that all depends, because the whole reason that the veterans nowadays are getting fucked over, I should put up a X rating or R rating, I suppose, with all the cursing, but all the government in 2006, all the parties got together and screwed the veteran over, okay? There was an all-party motion in 2006, and they had 1 hour debate in Parliament. If I was trying to figure out what was happening here, and I wanted to look at the Hansard, which is a record of parliamentary debate, I wouldn't be able to find it because there was no fucking debate. So you cannot screw over a group of people who go to war for Canada and then not follow democratic principles, okay? We didn't elect dictators. I don't give a fuck if all them parties agreed to it because they didn't have the facts. If you had the facts, would you do that now? I mean, look at all the mess they've done. They brought it in 2006, and then they came up with some bullshit about it being a living document, and they were going to change it along the way. You know what that means? That means they didn't do it right in the first place. They didn't put enough thought into replacing the Pension Act with a decent, full and fair compensation. And so they've been putting Band-Aids, as Lieutenant General retired Cuppins calls it, Band-Aids on it to try to fix it. Right? So they come up with a problem, they put a Band-Aid on it. They have another problem, someone comes forward to put a Band-Aid on it. Okay? They put Band-Aid solutions on this instead of throwing the whole goddamn thing out and starting fresh. Something like that. I don't know if they can even possibly do it. I keep saying, fix it by doing this. No taxes. No rehabilitation. No bullshit RISB, Retirement Income Security Benefit at age 65. But a true, whatever rate it is, I mean, 75, 90%, I don't care what they said of that. They got the law, they make it. But continue it for life. Not change it at age 65. So the earnings loss benefit's 90% up to age 65, and then now under the income replacement benefit, it turns into 70% of the previous 90% after age 65. But of course, they put clawbacks in there of the old age security, the Canada Pension Plan, the Canadian Forces Pension. So they put in there a false benefit. There's nobody getting it. That was my very first broadcast. It was about the Retirement Income Security Benefit. And the fact is, the Old Age Security Act says they can't do it. The fact is, the Old Age Security will want to take into account the Veterans Affairs benefits, and Veterans Affairs want to take in the Old Age Security benefits, and there's no fucking benefit to us. Okay? People might look at the Old Age Security and think that it's not being paid for. It comes from the government's generosity. Bullshit. You paid tax your entire career. Why would they try to say that you didn't pay for your old age security too? There might not be any specific mention that, like in the old days, it was commonly acknowledged that there were 3 taxes supporting the old age security. There was a 2% tax on this, 2% tax on that, 2% tax on something else. So they had a specific mention of how certain taxes were designed to raise revenue for the old age security. But somewhere along the way, that got shoveled off to the side, and now everybody thinks it just comes from general revenue. Now, it might be because of GST, because it was 2% on the federal sales tax. But the federal sales tax is no more. Now they have an excise tax that's called the goods and services tax, and they've combined it with the provinces and some provinces, and they've got a harmonized sales tax. Government always talks about all this harmony they want. But the thing is usually the harmony is a screwing over the person. Anyway, I think I might have been talking long enough on all this, but I'll mention one other thing. I've been doing all this stuff about bad faith. After I do my normal whatever I'm going to talk about, I talk about bad faith. And I was going to just talk about the taxes on medical marijuana. And it occurred to me I can call it that bad faith thing. Okay, I don't get medical marijuana. I buy recreational. I use it medically. Part of it is the reason that the government, I don't think, will give me a goddamn thing. I don't get anything from SISP. I don't get anything from back. I don't get anything but my pensions, my public service pension, my reserve force pension, and my Canada pension. Now, there are veterans out there that don't like the taxes on the medical marijuana. And taxes are it might seem like a boring topic for everybody else. For me, I was a tax collector for 16 years, so I can understand it. And I know that there's a thing called zero rating under the GST program, the goods and services taxes, that you can have a tax exempt product, but that's not as good as a zero rating. Okay, so you have two things. If a product is tax exempt, people might think that's great, but that means you still have to pay in your taxes as you're producing and making things and you're having a business. And if you're like doctors, I believe, want it to be considered tax exempt, but then they kick themselves after, I was told, when an expert told me, because they'd rather be tax exempt, zero rated than tax exempt. And here's why. Say you got a business and you set up something to sell prosthetics, for example. And prosthetics are listed on the things like that are zero rated. Now, you as a business have things like your vehicle and your gas and your electricity and your rent and all of that you got to pay GST on. But because you put in an input tax credit on a form, you tell the government, here's how much I paid to the other people. But because you don't have taxes you charged to somebody else, then you get a rebate from the government on the taxes you paid. So you actually never paid any GST. So if they want to they should make the medical marijuana zero rated, like all other medicines. The public policy reason behind not taxing food and medicine is that you can't increase the cost for the poor. You need medicine to keep you healthy or live. So by increasing the cost is not good. That's a public policy reason. So if you're going to have medical marijuana, and it has been deemed by the Supreme Court and other things, like the government, I guess, has accepted it, you can't very well then charge taxes on it, because that undermines the whole idea of taxing medicine. You can't tax medicine. Either it's medicine or it's not medicine. If it's medicine, there's no tax. If it's not medicine, you can tax it. But when I looked this up and I saw people were fighting, they had a case that supported the government, but it was all technical and relying on a thing called the Drug Identifier Number, the DIN. Now, think about something. Who assigns the DIN to a medicine? The government. So the government charges taxes against medical marijuana because it didn't assign a DIN when it had the power to assign it if it chose to. So that pisses me off to a great extent. Okay, it's like Veterans Affairs, in my case, telling me I wasn't hurt in service. And then the thing is, they're relying on their own decision to say, too bad. But the Canadian Forces said I was hurt in service, and Veterans Affairs said I was hurt in service too. So you have two departments that told me I was hurt in service, and then later they tell me I wasn't hurt in service, and that caused me to be hurt, confused, angry, whatever you want, okay? Because you ought to have people that are consistent. You might be wrong, but if you're consistently wrong, well, they're consistent. But to keep changing their mind makes us think that they're incompetent and possibly corrupt, right? It's one thing to make a mistake, but a man, well, I shouldn't say a man, but any reasonable person ought to be able to admit when they make a mistake, okay? You should be able to stand up and say, I screwed up here. But if you can't do that, then where are we? Anyway, I'm going to call it quits on my broadcast. I hope you enjoyed. I got a bit hot on their collar a few times. I might try. Listen, let me know. I'm thinking about changing the time because I think 10 a.m. I set that for my own convenience because I get up at 5:36 in the morning and then I go have a walk around the block and then I go play a game on the computer. And then I figured after a little while playing a game, I could get around to doing my broadcast. But it might be more convenient. I'm not getting paid for it, but it might be more convenient for the viewership, and it might be better to get the word out if I did it later in the day, maybe 2 p.m. I'm not too happy in the evening. I think I'd rather have my evenings free, but maybe 2 p.m. might be a better compromise. Let me know if you think a time change would work. I mean, it's not a democracy, I'll decide, but give me your feedback if you feel like it. Anyway, thanks for your time, and Anybody got any questions or comments along the way, send them to me now or later, and I'll try to take a stab at replying. Thanks.